We wish to acknowledge and welcome the representatives of Family Faith Freedom Barbados. At this point in time, we take the opportunity to remind you that your oral presentation is not to exceed 15 minutes. And I believe you're prepared for that. I would take the opportunity to turn to Mr. Hudson Innes to introduce the other members of your team. Sir, thank you.
Good morning to all. Madam Chairman, members of the committee, senators, members of parliament, thank you very much for giving us the opportunity to be here this morning. And my name is Hudson Innes. I'm the Executive Director of Family Faith Freedom Barbados. On my left is Davida Maynard Holligan. She is a practicing attorney at law, and she is also the Community Outreach Officer of Family Faith Freedom Barbados. And to her left is Reverend Carl Barker, who is a senior pastor of Shalem Evangelical Church, and he is the immediate past Vice Chairman of Family Faith Freedom Barbados. I'm not going to make the presentation. Mrs. Maynard Holligan will. So I'd be grateful if you will start your timer, ma'am, only when she starts to speak.
Very well, thank you. And Mrs. Maynard Holligan, sorry, I take the opportunity to remind you that the session is being streamed, so as you present to us here in the chamber, to the committee, you're also being viewed as widely as we are streamed. Okay, your time begins now.
Good morning to all. Family Faith Freedom Barbados is registered as charity number 1447 under the Charities Act. We are a Christian organization supported by members of many Christian denominations. Our aim is to seek to transform our society by promoting truth according to the dictates of the Bible, by fostering strong natural families, and by building healthy communities. We will, in this presentation, primarily examine the purpose of the Child Protection Bill and the Child Justice Bill. However, we opine that specifically with regard to the Child Protection Bill, the language is too wide. We encourage the review of definitions, including but not limited to the definitions of emotional, physical, and financial abuse. There are also critical definitions missing, such as the definitions of harm and danger. Further, we strongly encourage that a definition be given to moral danger, as there could arise a direct conflict between Section 5F, which introduces the concept of moral danger, and the established doctrine of parental rights, which vests in the parent the authority to determine the religious faith and associations of their children. We say that the role of the legislature is to construct the road and to provide clearly marked guidelines as to its boundaries. The judge is to ensure that we stay on that road. The role of the judiciary is separate. Hence, we ought to ensure that at this stage, all areas of ambiguity, conflict, and legal lacunas are aptly addressed and or rectified. These are not matters for judicial interpretation. Let us look specifically at the purpose of the two bills. We do not subscribe to the view that the confusing features of sexual orientation, gender identity, and transgenderism that have become commonplace in the United States, Canada, Europe, Britain, are simply features of a foreign culture being played out in foreign jurisdictions, and that we need not concern ourselves with these developments here in Barbados, as some persons have suggested. We have seen the early signs in Barbados. For instance, We have seen a transgender student at a secondary school insist on being accommodated as being of a gender other than his natural birth gender. At our University of the West Indies, there has been tabled the notion of accepting an individual's pronouns of preference according to the individual's chosen gender identity. We have seen the successful challenge of our Sexual Offences Act. These are but early birth pains. Our laws will be tested. These bills, when enacted, will be tested. In their current form, they fall woefully short of giving us as citizens the assurance that our treasured cultural, social, and religious norms will be protected. We see very clearly the evidence of this gender ideology being promoted intentionally by the United Nations organizations through the very instruments that we have signed on to. And this is why we are so strident in cautioning the drafters of our legislation against stating in Section 3(1)A of the Child Protection Bill and Section 3 of the Child Justice Bill that the purpose of the legislation is to ensure compliance with not only the specific treaties listed in the bills, but with all international instruments to which Barbados is a party. The fact that this is stated as the primary purpose of the bills weakens any argument we may later wish to make in the cause of making exceptions to accommodate the particular sensitivities of our local, cultural, and social norms. It is our opinion that the international gender lobbyists will not relent in the pursuit of their intention to infiltrate our laws as they seek to promote the infiltration, the facilitation and propagation of the gay lifestyle and transgenderism. We gave an example in our written submission of the legislative conundrum which can be caused. We stated that in response to a request for clarification by Costa Rica on the question of rights relating to the marriage of people in same-sex relationships, the Inter-American Court of Human Rights issued an advisory opinion on November 24th, 2017, stating that sexual orientation and gender identity are categories protected by the American Convention on Human Rights, which Barbados has ratified, in which all states must recognize and guarantee all the rights that are derived from a family bond between people of the same sex. Now, not only will our general legislative framework continue to be challenged, but with this ideology, we fully anticipate there will be pressure on Barbados to amend our laws to facilitate such interpretations, including ultimately the gender transitioning of children. Now, in discussions on the Child Protection Bill, it was stated by this very Joint Select Committee 2 weeks ago that the bill does not contemplate the handling of the issue of sexual transitioning of children, and that the bill does not provide for nor speak to the sexual transitioning of children. The Child Protection Bill does not speak specifically to sexual transitioning, but it does not need to in order to be utilized for this purpose. The application of the bill to sexual transitioning is tantamount to the concept discussed before this committee 2 weeks ago during the discussion with the Barbados Bar Association on the bill, speaking of the abduction of children from another jurisdiction being brought to Barbados under the Hague Convention. There is no great difference between the two applications. In both circumstances, we have a convention impacting its intent and its provisions upon our local courts and jurisdiction as a result of Clause 3(1)A of the bill. We note that the words which apply to the Hague Convention do not specifically appear in the bill. For instance, abduct does not at any time occur in the bill. Nevertheless, the construct and language of the bill, together with the parameters of operation given to the Child Protection Authority, will allow the authority to exercise its powers in accordance with convention. Now, the Hague Convention has a noble purpose, but our point must not be missed. The application of a convention activates the structures created in this bill so that they can and will be used to further the objectives set out in a convention. Vis-a-vis sexual transitioning, the bill becomes the legal framework for the operation of the convention for the sexual transitioning of minors. How Can the invocation of international convention allow such, you may ask? The interpretation, guidance, and advisory opinions given by the treaty bodies and the rapporteurs in respect to international instruments are changing rapidly. Here are some examples. The Universal Declaration of Human Rights now enshrines sexual orientation to all individuals, including children, in all modern references and interpretations, even though this concept did not exist when the treaty was declared. The United Nations Human Rights Council report on protection against violence and discrimination based on sexual orientation and gender identity argues for abortions and transgender affirming treatments and surgeries, including treatments and surgeries to children. The World Health Organization Human Reproductive Program publication entitled Sexual Health, Human Rights and Law states that countries are required to guarantee adolescents, and they define adolescents as children from 10 years of age to 19, the rights to privacy and confidentiality by providing sexual and reproductive health services without parental consent on the basis of their evolving capacities. Ladies and gentlemen, it is evident that the potential use of the bill for the purpose of sexual transitioning will be strengthened by the inclusion of Section 3(1)(a) that makes it explicitly clear that the primary purpose of this bill is to ensure compliance with all international instruments to which Barbados is a party, some of which support and promote a cadre of perceived rights associated with the concept of sexual orientation and gender identity, including sexual transitioning. We are not aware of any reservations that have been entered with respect to any of these inclusions or interpretations of international convention. The natural effect of the inclusion of Section 3(1)(a) is that our laws will be interpreted in accordance to the changing fashion of international law as outlined in these conventions. Accordingly, we recommend that the purposes given at Sections 3(1)(b) to 3(1)(e) of the Child Protection Bill ought to be the sole purposes of the bill. We go yet deeper. Clause 3(2) of the Child Protection Bill lists the factors that must be considered in determining the best interest of the child. The ultimate question then is, how will this clause be interpreted in light of 1, conventions to which we subscribe, and 2, the application of case law from jurisdictions which have embraced changes in their understanding of these concepts? It should be noted that our local family law is heavily guided by Australian family law. The idea of the best interest of the child is heavily guided by Australian law. Australian law is highly persuasive before the Barbados Family Court. In the Australian decision of WM against the Department of Communities in the Supreme Court of Western Australia, presented to you by Dr. Veronica Evelyn 2 weeks ago, the court determined that it was in the best interest of the child to remove the child from the protection of parents who, in the view of the court, emotionally abused the child by refusing to affirm the child's chosen gender identity and by refusing to accede to the child's wishes to transition to the opposite gender. Ergo, beyond sexual transitioning, this bill in its current form can be used to destroy families and can allow for the criminalization of good fathers and mothers. We observe that the bill also allows for a wide range of counseling services for the mental, psychological, and emotional health of the child and the family in Section 7(3) and others of the bill. It is interesting to note that at the start of Pride Month, the President of the United States issued a proclamation instructing federal agencies to combat the dangerous and discredited practice of conversion therapy. The President went on to say that additionally, his administration made it easier for LGBTQI youth to access vital mental health support, and youth can speak to counselors who have been specifically trained to support them. Honorable senators and ministers, is it not ironic that in the United States, counselors who have been trained to indoctrinate youth into the insidious scourge of transgenderism are seen as providing vital mental health support, but those persons trained to provide emotional support to youth who struggle with gender identity are being faced with prosecution and are even accused of practicing what is being deemed by the international community as conversion therapy. How will counseling and treatment orders be impacted by the inclusion of Section 3(1)(a) of the bill? Will the types of counseling afforded our children and family units change? Is this progression inconceivable in Barbados as we amend our laws to follow international trends? Gleaning wisdom from this event and others like it throughout the Western world, we ask that it be stated in the bill that nothing in this bill shall be construed to promote or encourage rights related to sexual orientation or gender identity, transition therapy, or the autonomous sexual rights of children of minor age. In closing, we recognize that our worldview is not the only one that has to be considered, but we are resolute in our conviction that our Constitution and our laws must reflect and protect the supremacy of God, and that Barbados must remain a God-fearing nation, irrespective of the diversity that exists among our population, to allow our laws to be infused with language that supports the evolving concept of gender fluidity with its unscientific, unproven consequences, many of which are yet unknown, particularly as they relate to the physical and psychological development of our children, is to put our children, our society, and our future at great peril. I thank you.
Thank you very much, Mrs. Maynard Holligan. How this works is that members of the committee would be able to examine with you a number of the aspects of the bill. In the first instance, we will turn to CPC, Chief Parliamentary Counsel, for initial responses. And in the meantime, though, one of the things that I would be interested in having you do is to identify specifically some of the concerns you raised, which I recognize as being fairly general, as was the written submission. I would hope that where you've expressed concerns about the gender fluidity and the other aspects, that you would be able to point specifically to where you would position the concern in the bill as it's currently constructed. That's for my benefit as chair. But at this point in time, I would wish to turn to Ms. Sean Bell for a response.
Good morning, Chair. Good morning to all. Just to acknowledge that, yes, Barbados would have been a signatory and party to the Convention on the Rights of the Child from the 19th of April 1990 and ratified the convention on 9th of October 1990. Through the ratification, states undertake to place in domestic measures and legislation compatible with their treaty obligations. The context of your argument is to say that if we remove the said offending purpose of 3(1)(a), for instance, in child protection, and the corresponding 3 in child justice, that therefore Barbados would not be bound by those obligations. But by virtue of the fact that we have signed on to it, we would still be bound by those measures. The only way then that we can really not be bound is to put in a reservation in relation to certain obligations, which as a sovereign state, we have the right to do. Now, you would also know that within international law, there are certain restrictions in terms of what kind of reservations can be made, and in terms of if it goes directly to the substance of the convention, or something like that. So the fact of the matter is, removing this provision would not then release the legislation from being bound by them. It is also to say that those international conventions, especially in relation to, both child protection and child justice, they represent the standards as it relates to child protection specifically. And the understanding of a child in need of care and protection, and it needs to be stated, is set out in Clause 5 of the Child Protection Bill. It is important to note that this is not a bill that sets out to speak to parenting. What this bill is supposed to do is to be invoked where a child needs care and protection. So that in Clause 5.1, you would see the articulation of where a child needs care and protection. And I will just take the time to speak to it so that members of the public also would get an insight into what the substance of the bill is to take care of. And it's also reflected in the same 3 as well. So a child is in need of care and protection where the child does not have a parent, the child does not have a parent who is fit to exercise care or guardianship owing to mental or bodily disease, infirmity or incapacity, or any other circumstances providing for his upbringing, and there is no available person or persons capable or fit to be or willing to take care of the child, where the child has suffered harm or by neglect of a child or the failure of a parent to supervise or protect the child, adequately supervise or protect the child, where the child is a victim of abuse of exploitation or having been exposed to such exploitation or abuse, has been abandoned or deserted by his parent, has been exposed to danger, moral and otherwise. Just to say, in terms of moral, that has been pointed out by other submissions, and there was at one point a decision to actually remove it, so just for note. Has suffered physical, emotional, or psychological harm caused by being exposed to domestic violence by or towards a parent or other persons residing with the child, where the child suffers from a mental, emotional, physical, or developmental condition that requires treatment to cure, prevent, or ameliorate the effects of the condition or harm suffered, and the parent refuses or to obtain treatment or is able to or available to consent to those services, is in custody of the director or other person, and the child refuses or is unable to resume custody of the child, and the parent is unable to resume custody of the child. A child that is beyond the control of the parent, a child that is a threat to himself, a child that is less than 12 years old, and by virtue of the 3rd schedule has committed one of the offenses in the 2nd or 3rd schedule, but cannot be held criminally responsible. And then those in need of care and protection according to, and the reference there would be section 40 rather than section 39 of the Child Justice Act. It is also important to appreciate the place where you would invoke interventions for medical purposes, so that you have the definitions of care responsibility and delegated care responsibility. So care responsibility would deal with when the authority has been vested with the custody of the child, where care and protection of the child has been declared, okay? Right, so that care and responsibility would allow for the authority, for instance, to consent to medical treatment not involving surgery for a child on the advice of a medical practitioner, and consent to medical treatment involving surgery that a medical practitioner certifies in writing needs to be carried out as a matter of urgency and in the best interest of the child. Now, you would have cited references to other cases, for instance, in Australia, right? And there were other cases that were submitted by Dr. Evelyn as well. As I would have observed then, those cases would be persuasive, but not binding. And you also have to take into account the way that legislation is interpreted. So that in the case where you're talking about surgery as a matter of urgency, it would take the dictionary, the ordinary dictionary meaning of the word, and not an interpretation that you would impose upon it by an authority that only has persuasive standing within this jurisdiction. So that it is urgent as in right away, immediate, right? Even from examining the circumstances of the cases, you would recognize that there were medical examinations, psychological examinations, all sorts of different examinations in order to get to the conclusion of the medical doctors. And even then, even in the circumstance, the immediate case, even if you look at the very circumstances, the immediate problem in those circumstances was the threat of suicide, in which case it can be argued that the real and proper treatment is to intervene to deal with suicidal ideation and not sex change. And so therefore I put that to you, and for you to understand that in that way, to me on a local level, that is how it would be interpreted. But especially within the context of this bill and the meaning of urgency, it would not match with the circumstances that you're trying to put forward, that would have been presented in the context of those cases. And again, I stress, they have persuasive weight, but not binding weight. So those are my initial comments. Thank you very much for your attention.
Any other member of the committee before I ask Family Faith to respond? I recognize Mr. Trevor Prescott.
Good morning to everybody. Conventions and treaties, I assume, will have tremendous impact on local sovereignties. Now, if it is said that we have signed on to all the conventions listed in the section that speaks to the purpose of the legislation, dealing with the United Nations Convention on the Rights of the Child. If we did not submit our objections to any of the tenets within that treaty at this specific time, are we in a position now to submit anything that we consider that we ought to have excluded at this specific time when we sign on to the convention? I'm a little concerned about that, if there's provision, and if by oversight, I'm just putting in that word, we did not object to any of the provisions then, do we have the right to now exclude ourselves from any specific tenet within the convention itself? Because I got the impression that this faith-based organization, charity, is placing a lot of emphasis on sexual orientation. And they're saying that there's a provision within the treaty that allows that that is considered as still a legal instrument on sovereignties equally as powerful as statutory law within the independent sovereignties. Can we exclude ourselves at this point if it's agreed that we should?
Chair, through you, just to say that the time at which you put in a reservation would be at the time of, just give me a moment in terms of, so that it would be, great, at the time of signature, ratification, acceptance, approval, or accession. So at the time, Barbados did not submit their, those particular reservations. And it would be noted that at that time, there would have been no such interpretation in terms of how those things would have been understood. Barbados then would have to seek to try to put in a reservation, or you can, as suggested by the organization, you would have a specific provision that would be speaking to this particular scenario. However, I would take pains to indicate that the scenario that they're speaking about in terms of how it would be interpreted could not be lead to the interpretation that is being averred. Because you have to look at the language of what is set out in the bill. And at the end of the day, in terms of full ratification on the ground, the full ratification takes place with the domestic application. Yes, you would be under an obligation to carry out those measures on the ground, but they're not fully operational until you do so.
Mr. President.
No, the other thing that I would like to add is if the intended statutory provision now is approved at the highest office of the land, Parliament, can the convention or the treaty, is mentioned here as a convention, the convention will have higher status in our sovereignty than statutory law. It can't have higher status than constitutional law, but does it have higher status than statutory law?
The way that okay, so in order to have full domestic application, there must be legislation on the ground. Okay, so that is where it is. What can happen is that treaties can act as extrinsic aids into interpretation of the legislation, but it can act as an aid, but it is not the end all or be all of how the legislation would be interpreted. So that is how I would answer that.
Any other member of the committee? Okay, hearing no further interventions at this time, I would refer back to the family faith freedom, and I would hope that you could also lend some clarification to my earlier question regarding the specifics against the background of what I termed generalizations of your earlier statement.
Thank you, Madam Chair. I want to first answer, or give my answer, which is quite different to that last question of whether convention can then have a higher status than local law. And the Constitution is the supreme law of the land, as is stated. But in this bill, we are stating that the primary purpose of the bill is to comply with treaty. The primary purpose, first and foremost.
Can I intervene?
Yes, please.
Are you referring to section 3.1?
Yes, ma'am.
Section 3.1 says, "The purpose of this act shall be to ensure compliance with," and it has 3 bullets, "to promote the welfare of a child, to provide care and protection for a child, protect a child from abuse and neglect, and ensure that the best interest of the child is given paramount consideration in all matters." So I'm conscious and interrupting only because I would want us to be clear and factual in our submission.
Yes. So we have here to ensure compliance first, not the best interest or welfare of the child, but to ensure compliance with, and I will just sum up Section 3.1A as international instruments and convention. Then we do proceed to the welfare of the child. So my understanding of that is in pursuit of ensuring that we have the best interest of the child, or we promote the best interest of the child, we are first looking at international convention. That is given great weight based on this provision.
Mrs. Maynard Holligan, would your submission then be that that does not take primacy in terms of where it occurs, but that instead of bullet A, it be bullet E? Because because what you are speaking about is the order that it appears first, but I think that Ms. Bell is best suited to respond to this. But my limited knowledge of the law is that when you go through all the bullets and you have an "and," whatever the order that they come in, it is "and" all of these things taken together is the purpose of the act. Ms. Bell?
Yes, Chair, so that the penultimate paragraph has the word "and," which means that all of them are to be interpreted together. Additionally, the purpose of those particular conventions and instruments, in context, the primary purpose is to serve the best interests of the child. So it is in league or in compliance with all the other cited objectives, B, C, D, and E, so that it is not running in conflict, but actually they are in harmony.
Okay, I hear you. I believe, though, that the conventions will be given great weight. But not only will the conventions be given great weight, case law will also be given great weight. And they are not simply persuasive. They are highly persuasive. That Australian case, Australian law is highly persuasive in our court, especially dealing with matters of the best interest of the child. So, given 2 things, that case law in some of these jurisdictions are starting to construe these terms different from how we have known them. For instance, the case where emotional abuse is seen as a parent disagreeing with a child's stance on gender, on his or her gender. So case law from jurisdictions which are highly persuasive are changing their understanding of these concepts, 1, and 2, convention, as we have ratified it in 1992 when various years, and what it meant then is not necessarily what it means now. Now, the word may not have changed, but before, where equality meant X, equality now means X minus 2 plus 16. The meanings of the words have changed, and this is seen in these various reports and documents which are issued by these treaty bodies. What am I saying? I am saying when we look at convention, whereas I grew up thinking convention, beautiful, UN convention, there is no law as wonderful as the Human Rights Declaration. I can no longer say I have that view, because what it meant in 1992, where we all stood for freedoms and joint rights, we have swiftly been pulling away from that. And I encourage you to go and look at the reports being issued from treaty bodies, if you are not already aware. I'm not saying you are not, but I encourage you to, because you see in these reports statements and definitions of things that are very far from what we have come to know and understand. And these treaty reports are like journals. You are not a doctor without being in tune with the medical journals. You are not a lawyer without knowing case law and being in tune with the journals. They inform your interpretation. And they will come back here when we look at statute and we see emotional abuse, lovely word, but what does it mean? Let's go to the treaty, let's go to the journal, let's go to the report, let's go to the case law. The interpretation given by places and jurisdictions and convention bodies that we look to and we respect, these things are changing rapidly. They are not what they once meant. They no longer mean these things. Madam Chair, to go back to your question, I am indeed concerned about the inclusion in Section 3.1 of, excuse me, we are concerned, I do not speak for myself. I'm going to the section of the international instruments, United Nations Convention, the Universal Declaration of Human Rights, and all international instruments. I am concerned about the inclusion of that. And furthermore, we suggest that be stated that nothing in this bill shall be construed to promote or encourage rights related to sexual orientation or gender identity, transition therapy, or the autonomous sexual rights of children of minor age. Now, when the child becomes an adult, that's the child's decision. But as a child, we are to provide a safety net. We are to allow them to develop and really test who they are before they make critical decisions that can be irreversible. Some of these hormone therapies and surgery. Now, I know that, and CPC, I understand your point, but if we are going to, and the court depends heavily on the decisions and case law of Australia and other jurisdictions. Other jurisdictions are changing how they interpret these words. Now, if our courts are going to be looking at these things, it will automatically mean that our court must they will ask themselves, are we then to change how we interpret these words as are in this bill? And the bill is, there's no specific definition given of emotional abuse so that the court can say, well, this is how they interpret it, but the specific definition given here, this is one of the areas, for instance, in Section 3, nothing specific or tight given to emotional abuse. The definition of physical and financial abuse, these definitions are too wide. So if the court can say, well, they are interpreting these things this way, but on my bill, I see a tight road. I must ensure I'm within my road, I'm within my boundaries in my interpretation. So it is therefore clear that I cannot interpret outside of the definition. Our definitions are too wide. So then the court can, according to the particular justice and his or her interpretation, bring to Barbados interpretations such as what has been seen in the case of WN. I just want to say a few more things because you spoke about a few things. You said that in dealing with children, we're not necessarily dealing with parenting. They are two sides of the same coin. I don't think one can be eliminated. They are two sides of the same coin. Section 5 of the bill, again, it is not just Section 2's definitions, it is also Section 5. I'm glad that you said that you're considering removing moral from there. Let me go to Section 5. Now, Section 5 is heavily dependent upon Section 2. So for instance, if I just say mental, emotional, physical harm, then I must, of course, go back to Section 2. So the original grievance of the definitions in Section 2 being too wide comes back up here. Because then when I go to Section 5 to say, these are the grounds on which I can say that a child is in need of care and control, then there is a plethora of interpretations now that can be entered for what is physical or emotional harm. The words harm, the words danger have not been defined. And CPC, I hear you that we would look at the dictionary, but we will not only look at the dictionary. We will also look to the same case law, where these words are being given different meanings. We will also look to the same conventions and the reports and so forth, where these words are being interpreted differently than we have known them for decades to mean. So we are opening the floodgates here in Barbados unless we tighten up our definitions so that we say this is what you may mean, but this is what we mean. We need to be very clear.
So just to be clear, your challenge is not with an absence of definition, which you've stated a few times. Your challenge is with the definitions as expressed in Section 2.
The definitions that are expressed are too wide, one. But then there are some words that have no definition. Harm, lovely word. What does it mean with respect to...
You have suggestions for language that can be considered by the drafters in review?
The committee, ourselves and others will be happy to submit something, but at this time, I am not prepared to submit the definitions. Again, this is something that is done as a group. We would sit down, we would take our ideas of tighter definitions, and where definitions are missing of definitions, and we'd be happy to submit those.
Well, the thing is that you had requested the written submission followed by your oral presentation to make clarity. And as we have been saying, we hope that where there's a challenge on something like definition, that you would propose ways in which to close the gap where you see definitions are too wide. I would like to suggest further that the window open to you is very closed right now, because once this presentation is concluded, we start going through, based on the written submissions and the oral presentations, we start going through clause by clause where amendments have been proposed and what those amendments are. If the drafters consider that they have closed the gap, for instance, on definitions as much as they can, and they don't have a position to balance that against, then you understand where the problem would be. When coming to these sessions, I would just urge members of the public, where you have a challenge, state the challenge, also state the solution, because that's the only way that we get the most constructive use out of the process. All right, but I do recognize we're up against the time, so I'll give you 2 minutes to respond further, and then I'll ask CPC to come back in.
Thank you very much, Madam Chair. I just want to point out within the 2 minutes that we have not taken issue with sections 3.1b to 3.1e. In fact, we said that we recommend that the purposes given at those sections of the bill ought to be the sole purposes of the bill. Our primary contention here was with regard to the treaties and the latitude that has been given by recognize in both bills that, well, specifically in the Child Protection Bill, that the treaty, that the bill conforms to all instruments that Barbados has signed on. We've talked a lot about interpretation, and that is very important because the interpretation that follows the enactment of the bill will be something that we can be seriously affected by. The CDCU had mentioned a couple of times the question of what is binding and what is not binding. And that is crucial. What is binding and what is not binding? Because when we signed on to the Universal Declaration of Human Rights, that was back in the early 1990s. There was nothing in there about any sexual orientation or any of the other things that have been added subsequently. The problem with leaving that clause, which states that the purpose of the bill is to conform to all international instruments to which Barbados is a party, is that coming out of these instruments, there are interpretations which are not binding because they're interpretations. We haven't necessarily signed on to them, but they become binding because there is great pressure exercised on us to include these things into our laws. And herein lies the danger. We made reference to the question of the Latin America, the interpretation of the Latin America Court of Human Rights, where the original document that was signed didn't have anything about same-sex marriages and same-sex unions and so on. But because of the interpretation that has been given specifically by the Inter-American Court of Human Rights, pressure is now being put on us to enact in our legislation, in our coming legislation, the provisions that they are saying must follow. And this has happened in this is happening in a number of these international treaties and the UN treaties. So it's the subsequent documents, the subsequent reports that come out following meetings that create the danger, because the pressure is being brought on us to change our legislation, to amend our legislation to include the things that they want us to do. Only this morning, just briefly, let me make this last point if I may. Only this morning, I heard the end of a news report on CBC radio. Didn't hear the full thing, but I captured a part of it, where it said that our representatives to the UN have just signed and just ratified a number of documents, and they ratified some and they noted others. Now, if you note something and don't ratify it, it means that you have some concern about that, so you're just noting it. You're not at the point of ratifying it yet. And this is where we see the danger, because yes, as you rightly said, madam, we have the possibility of including reservations. But when a reservation submitted, the report that I heard, it spoke about noting certain things. It didn't. I haven't heard anything about reservations. And I don't know if it related to the Cotonou agreement, which is the subsequent agreement to the Lomé Convention. The old Lomé was for 20 years, then that went into another 20 years, and now we have the post-Cotonou agreement, which was supposed to be signed in July, and it was moved back to October. I don't know if it had anything to do with that. But that That document, which is a trade agreement, now has no less than 100 references to human rights. And all kinds of things have been put into that, which become binding on us as we go forward. And this is what we are bringing attention to.
Right, thank you, and I interrupt because your last concern is actually one that was presented before, so maybe it would be useful for CPC in the rapid response to clarify the point at which reservations are made, to speak to the difference between noting and ratifying, to also make some reference to the point that where reports that relate to instruments may say certain things, that they don't have impact unless there are amendments made to the instruments. I happen to participate with one of the UN organizations that follows that specific. There are reports that can come out of instruments, but unless those are brought as formal amendments and adopted as amendments, as an amended document, they're just reports that may be used for persuasive arguments and so on. So CPC, I think that there are some broad areas that you may wish to comment on and some other specific concerns.
Yes, Chair, just to say that we emphasize the fact of where agreements to which Barbados is a party. The right of Barbados as a sovereign state to enter in reservations. The reservations can be put in at the signature, at accession, at ratification. In terms of your raising the point about noting, that's what it means. It is noted, but it is not that we have agreed to be bound. And in order for the full application of a treaty to be felt on the domestic level, there has to be reflection on the legislation on the domestic level. In terms of the cases and being highly persuasive, note your language, highly persuasive, but not binding. And at the end of the day, the courts have to weigh the legislative structure that you already have in your jurisdiction, the case law that may, in fact, touch and concern this area, even if it's not direct, and apply it with the language that is actually used and informing the dictionary meaning. But there are also other canons of statutory interpretation as well, such as the meaning of the words would be influenced by all the words around it and the context of the particular legislation. And at the end of the day, it has a central focus of protection of the child. I appreciate that you are saying that there may be a time where, or there is coming the influence of or international pressures. But at the end of the day, you have to appreciate where Barbados is. If it is that we've signed on to something, then there are certain responsibilities that we would have to follow through on unless we sit down and put in the reservation. And there are certain ways that things can be bound on the domestic level. And you have to also note the conditionalities on the ground. All the case law that would be there, all the interpretation and statutory canon, because I have to make the case here that legislative drafting, that statutory interpretation is not creative writing. There are rules and canons and conventions that bind how you interpret legislation. And it is for that reason that I would say that in terms of your immediate concerns about the surgeries and so on, the bill does not, in its wording, give the opening for that interpretation. Thank you.
Thank you. And finally, any other comment from any other member of the committee?
Madam Chair, I just want to make this point. It is not legally technical, but is a fear which I have about third world countries asserting themselves and protecting their people, especially when we are faced with the impositions of international law, treaties, and so on. Based on conversations which you have had, I extrapolated that we very seldom express our reservations by noting these conventions and indicating clearly that the probability is that we might not even support provisions in the conventions or the treaties in the law. And then at the local level, we want to pass legislation, and there are some social facts that we do not want to include in the legislation, but because of administrators' fear of coming in conflict with the impositions of the international law, a type of conflict in the law places us in a difficult position. Now, my view is that this is where we are at present. I can't do it any better. I would like to give a synopsis, but I can't do it any better. And therefore, I believe that this must be overtly stated that I got from these discussions that Barbadians and many important NGO institutions have the fear that the impositions of sexual orientation will occur or will be allowed if the bill goes through as it is. But there's also an understanding that conventional laws or treaties, well, not so much conventions, but the treaties that we're saying, also gives that latitude for us to interpret it. It is implied in a sense in the international law that likely to bind us. I think that's what is happening, and I think it's a matter that we outside of the legality of the discussions. I think at some time we have to deal with these sociological implications of the legislation itself. And that has to be allowed, or not. To me, this committee is actually avoiding the reality that we seem to be facing.
All right, thank you. And we are out of time and actually in breach because we have gone beyond and should have moved. Someone should have moved a motion for us to extend the time a little bit. All right, so thank you to the Family Faith Freedom Barbados for both your written submission and your oral presentations. We do think that we had a very useful exchange. And as Mr. Prescott was saying, even in his wrap-up, there are some aspects of the concerns raised that will certainly cause the committee to reflect to see where clarity and greater comfort can be given within the context of the concerns raised. So thank you again, and do have a beautiful day.
Thank you. Have a good day.
change that would weigh into our final analysis of the bills before us. So without further ado, I turn over to, I don't know who is leading the discussion, Ms. Dujon?
Thank you. Good morning, everyone. Thank you for having us. My name is Felicia Dujon. I'm the third Vice President of the Democratic Labour Party. This is my colleague, Ms. Tyra Trotman. She's also an attorney and also part of the Young Democrats. It's a pleasure being here. We want to appreciate and, of course, thank you for the opportunity to invite us to speak on such an important legislation in Barbados, not only for us as individuals within a society, but also for the protection and safety of our children. We also reserve the right at any point for us to continue to submit when it's necessary, because we believe it is our role and responsibility to submit to any factors that may affect us within our society. Given the matter with the Child Protection Bill, we have discussed this matter for the last few months. Since June, when we came across the bill in Parliament, we thought there were some major concerns that we thought should have been brought to the attention of not only the government, but also to the public domain. As we have submitted our written documentation, we also want to just briefly go through the comments so that we have some idea of what is happening. For instance, the bill in itself seeks to look at a one-size-fits-all policy, meaning that it takes in consideration or may take in consideration that all families are the same. And as such, the bill is structured in such a way that it seeks to penalize certain persons that may not fit into that category. And of course, we can understand in our Barbadian culture and our Barbadian society, there are diverse families with diverse concerns, economic concerns, and in some cases, concerns that may, in some cases, affect them and how they conduct the business of a family structure and as being a parent. So the financial distributions of family is very important. It seeks, as we said before, to penalize the poor, the vulnerable, the most vulnerable in our families, in our society. And we have seen that. Last few weeks, we saw a mother and her children right across from here. And she could not afford a home because of her economic downturn. And these are real issues, so that when we create in legislation, it is not the abstract documentation, but how does it affect the lives of every single citizen within this society. And as a result, we ought to ensure that whatever legislation is being passed, that we take in consideration that every life matters, and every parent and every child and every family and every household matters. And so we have to take that into consideration. Our recommendation is that such policies require diverse research so that we can take into consideration every family within Barbados and how the economics and financial outcomes may affect their ways of distributing the parental responsibility. Because many times we speak of parental rights and parental responsibility, but at times not every family may be able to afford and have those challenges. And I believe the minister did touch on that, that even at times we and the institutions that are mandated to assist those families for welfare may cut short. And these families are left at the mercies of the state. The second most important aspect of what, as we have seen in the last few presentations, is the language. And we see quite a number of discussions on the language in terms of the ambiguity and, of course, the complexities of language that has been used. And, of course, we saw in terms of the shall and the may, and how do we define the interest or the best interest of the child. We, as the Democratic Labour Party, believe that any legislation that is being passed, it cannot be ambiguous, meaning that it has to be clear for the average citizen. We cannot create laws and allow it to be ambiguous. If the law is ambiguous, the fault is at the administrators and the legislators, not the common man or woman. They ought to understand what the laws are. So the language used in the Child Protection Bill collectively needs to be clearer. and it needs to be classified, particularly when it comes to the removal of a child from his or her home, particularly in extreme circumstances. And as I said before, I will use the backdrop of the mother with her 2 children on that day when the children were removed from her. It was not her fault that she was placed in those circumstances, but the children were removed. And as I said, I know if you've seen the research, when you remove children from their parents, it's like a death sentence for them. And we have to take those into consideration. The third aspect, as I said before, in terms of the recommendation, because I believe that when we highlight a problem or a concern, that we try to provide solutions to those problems, so that there must be some kind of provision in terms of how does the law help and assist those families, and that we don't have those kinds of ambiguous language like necessary, like neglect, and things of that nature. I will briefly go through the fourth one, and my colleague will come on as well. The very fourth one, which is on page 4, where the Child Protection Bill undermines parental rights, and it seems to replace the authority of the parent to the authority of the director, which my colleague will highlight very shortly. Parental rights is very important. Why? Because a parent may have responsibilities, which speaks in the bill quite a lot with responsibilities. And just to break it down to common language, you have the responsibility to feed your children, to send them to school, to ensure that they do their homework. However, it is also your right to know what you feed them, what kind of medical attention that they should get, as opposed to the state. So when those kinds of rights are removed from the parent, it becomes a very dangerous precedent. And of course, we will discuss that a little bit further. Parental rights and parental responsibilities, though they may work intertwined with each other, they are separate entities legally. So a parent's right cannot be overridden by the state, and that's very fundamentally important. I will give you again the same example with the mother with her 2 children. It was her right to try to keep those children safe, and she brought them to a homeless shelter, but of course we understand the circumstances with that. But the reality is that at the end of the day, the children were taken away from her. We read in the news report that the mother signed over her waiver so that the children could be in the child protection care. However, if you're in the state of 2 policemen, chances are you will sign if you are in, of course, out of fear and everything else. We have to take that into consideration. The Child Care Board is really social services. And we have to remember that we have to assist families, not criminalize them. The very fourth one is that the Child Protection Bill creates more foster homes and child care centers. Of course, if you're removing children from their homes because of all these arbitrary conditions, you will see a highly increase of children being placed in those kinds of areas and circumstances. And of course, we've seen that. And one of the concerns that we have in those child care centers and of course foster homes is that the new Child Protection Bill does not speak about the pre-qualifications of those individuals. And of course, we have understood how that has worked because the Child Justice Bill actually removed some of the kinds of harms that were being done to children in those centers, including flogging and corporal punishment of children by state agents. We have to be very careful and very mindful of that. So overall, we're saying that the bill is too wide and too general in that sense, and we've highlighted and we can go through them. Definitions and interpretation is very important. From page 11, we're seeing that what do we mean by care responsibility? Of course, the definition for parental rights must be inserted because we cannot have the child protection or the child care board or the authority making decisions, particularly when its decision does not take in consideration matters of emergency. Of course, if your child is severely harmed and that child needs a medical emergency, of course the state has to step in, but you need to counsel the parents. It is very important. So we will see that again. We're seeing in terms of a child in need of protection and care. Again, the standards that it gives in terms of mental issues to deal with treatment, all of those factors, it has to be clearly defined. Because as a philosopher myself, when we see that kind of language, it can be interpreted. And of course, all this legislation, at the end of the day, it gets you to the point of the judge, and the judge has to decide as to what exactly it's saying. Emotional harm, that has to be, it will be again very problematic in terms of how we define that. Do we need various aspects of it? Neglect of the child, which is very important, because the neglect of the child in this current child care protection bill, what it actually does, it exonerates the state. So it only penalizes the parent and not the child. So given that we have, in terms of the time, I will allow my colleague here to touch on the matter to do with the legal status of this bill.
Pleasant good morning once again. I want to say thank you for giving the Democratic Labour Party the opportunity to make the presentation before you this morning. I am definitely honored and humbled to be before all of you this morning. So I will just touch on something that my comrade would have touched on, which is the section 22.3. My issue from a legal standpoint of this particular section is that even though it says that the removal of a child shall only occur where it's necessary to protect the child from risk of serious harm or danger, my issue with that word necessary is a very discretionary word. Necessary, what may be necessary to one person may not be necessary to another. And we're dealing with a director, yes, which is a statutory creature, but at the end of the day, that person is still a human being. So depending on who the director may be at a given point in time, you may have a situation where what was necessary to that person acting at the particular time may not be necessary to another, and then you find inequality in how the law is applied. So my suggestion there would be to create a subsection which then creates different factors which are taken into account when determining what is necessary. Also, that word risk, that's a weird word to use in a piece of legislation, because what's risky once again to one person, or what's risky in one situation, may not be risky in another. So once again, I would say add a subsection which clearly defines what factors need to be taken into account when determining what is risky. Further, I would say that the whole notion that the offenses created by the bill are tribal summarily is problematic. Not so long ago, it was reported at a criminal law justice symposium, which was held at the Hilton Resort. I believe it was in April of this year. It was reported that we have a backlog of 16,000 cases, and that's only at the criminal level. That does not encompass the civil cases and the new cases which come in every day, 16,000. So obviously, if you're creating offenses which are tribal summarily, you're putting more pressure on that system. And then my concern is, I don't believe that the factors which contributed to that backlog have been adequately addressed as yet. For example, their magistrates, they're still writing longhand notes. So there's no infrastructure which you would see at the High Court level. For example, the simple thing of creating microphones that then create a transcript instead of having them write notes, which after every 2 sentences you have to pause. That obviously takes up time. And then there's a small pool of magistrates. I think we need to widen the pool, so you don't have a situation where, because a magistrate is on leave, you know, cases can't be heard. Right now I'm getting dates in next year at the magisterial level. So that just speaks to the difficulty we're having. So my suggestion, or the Democratic Labour Party suggestion, would be to create an independent tribunal. It's not a new concept. It's been done before. You know, we see it with the employment law, the labor law. We have tribunals in place already, and it has been a successful mechanism. I don't think we need to further burden the magistrate courts, especially in circumstances where what's causing the burden has not been addressed as yet. I would also like to draw the committee's attention to section 7.5, which states that this section, where the views of the child differ from the position of the director, the child may, within 13 days of the notification of the position, appeal to a judge in chambers. My issue with this particular position is not necessarily that the child has the right to appeal, but I think that the parent should also be given that equal right to do so. Obviously, we support that children are given more rights. We definitely support that position, but there needs to be a balancing exercise carried out. So although we want to give children more rights, we also don't want to take away those rights of the parents, because that is a natural right given by God and not man. And therefore, we don't want to be put in a position where we now have legislation which is taking away that God-given right. Additionally, I would just like to reiterate the point that my comrade made in terms of, I find the language of the bill in of itself is seeking to replace, I don't know if it was intentional, but seeking to replace the rights of the parent with the authority of the director. And I think this is something that we need to approach very carefully, because we don't want a situation, we've seen examples in other countries where this might have been a bit problematic. My comrade highlighted a situation recently where children were taken away from a mother. So we don't want a situation where, even though we have parents who may be putting their best foot forward and really trying to do the best for their children, we're taking children away from them because they're falling short. I think there are a lot of social and economic factors which need to be looked into and addressed, because this is a piece of legislation which operates in a country, and I think we need to look at the circumstances of the country, social and economic factors, and not just put a piece of legislation in place and not look at the activity that's happening right now. A lot of people are struggling. A lot of persons, especially in Barbados, they're raised by single parents. A lot of these single parents, they work 2-3 jobs just to make ends meet. So we don't want to put those parents who are truly trying to do the best for their children, in a situation where we potentially, have their children taken away from them. Obviously, we want to protect children from real neglect and abuse, but I think there's a gray area, which is, the parents who are really, really trying their best, given the circumstances, to make ends meet. So I just wanted to keep your presentation quite brief. So that is, what I have to say this morning.
And I assure you the chair has already extended you some grace. Thank you for your submission. I would allow for members of the committee to raise any observations with you, any commentary with you after providing for CPC. And I'm sure that in her own presentation, she'd be able to suggest to you that there are some aspects of the concerns you raised that have already been considered and taken on board. So you'll be pleased to hear that in the response from CPC.
Chair, through you, just to indicate that it must be made clear that the jurisdiction of the legislation is supposed to be speaking to children in need of care and protection. Care and protection is articulated in Clause 5 of the bill. We would have gone through it in a previous submission, but let's look to them again to make sure that you understand that there would have to be these circumstances in order for there to be an intervention. This is where the child does not have a parent. The child does not have a parent who is fit for care or guardianship, and it explores those circumstances, has suffered harm, neglect, failure of a parent to supervise adequately as supervised, victim of abuse or exploitation, abandonment, exposure to danger, moral and otherwise. It should be noted that the word moral will be deleted. The suffering of physical, emotional, and psychological harm, the suffering from mental and emotional and physical abuse, and then they go into an explanation where the child refuses or where the parent refuses or is unable to resume custody of the child, where the child is beyond the control of the parent, and the child is a threat to himself or others, where the child is under the age of 12 and has committed an offense ordinarily that would constitute an offense but cannot be held criminally responsible, and the circumstances of care and protection as it relates to Section 40 rather than Section 39 of the Child Justice Act. And just to go into just the areas that the Child Protection Bill goes into, basically setting out the importance of child participation and the paramountcy of the best interest principle, child participation as in Clause 7, and the best interest principle 3.2 and Clause 9.3. It articulates the key procedures for child care and protection process, from reporting through the investigation and placement, and that is spoken to in Part 3. It recognizes the need for care planning and offers some helpful guidance on the general approaches to be taken in this and other child protection procedures. It establishes a new and much needed court protection orders to speak to protection, rehabilitation of children. It speaks to the intersection of the conflict between children in conflict with the law and the need for care and protection. It speaks to the administration where it introduces some new actors, the Child Care Board then transitioning to become the Child Protection Authority, the introduction of the Child Protection Board and the Director of Child Protection and the staff of the authority. And speaking thereon in terms of the Director, note that with the Clause 5, speaking to the jurisdiction, then you would have to go to Part 3, which speaks to the grounds on which you can make interventions. So Clause 22 speaks to the grounds that the Director can make interventions, where there's a request of assistance in relation to a child, where he receives a report that the child is in need of care and protection, which would have been stipulated in Clause 5, and it appears to the Director that a child is in need of care and protection. Clause 2 then, subclause 2 then goes into what is determined as an appropriate response to a request for assistance or to report concerning a child. The Director shall have regard to the following: the immediate safety and welfare of the child and any other child in the usual residential setting of that child, the age and maturity of the child, any disability of the child, and the existing circumstances of the family. That includes those economic issues that you would have been speaking to. The Director must take those things into account. I will draw your attention as well to the nature of the Director's powers in relation to investigation, particularly Clause 28.3. An investigation by a Director may include the analysis of the following matters in relation to the child: medical, health, social, residential, educational, and economic, as well as any other factors relating to the life of the child. I draw these things to your attention so that you appreciate that the bill must be taken as a whole and not in parts, and they work in tandem together. And as such, it cannot be asserted that it doesn't take into account the economic factors, but in fact sets out in the bill specifically that the Director needs to take those things into account. And it also sets out the jurisdiction that when it is supposed to be invoked. This is not a bill to deal with general care and protection of children. This is a bill dealing with where a child is in need of care and protection. Those things are already stipulated in Clause 5. Thank you.
Yes, good morning. Just again in response to that. So while we do appreciate that this bill is to protect a niche of children. It's not just a wide provision on all children. I think we want to prevent a situation where there's abuse of the law. I think that's what we're really concerned with. And that usually happens where there's ambiguity in the law. Because myself as a legal practitioner, we know that we can find loopholes where there's ambiguity and stretch those loopholes. And depending on how we argue, we can find situations where we abuse the law, really and truly, because there's no tightness to it. So you have to be very careful, especially in a situation like this where you're removing a child from a home. I think the language needs to be more tight, it needs to be more clear. So on the flip side, there's not a situation where you have legal counsel that can then go and defend perpetrators and get away with it because the language is too general, too ambiguous, too loose. Also, you mentioned consultation, also looking at the circumstances of the family, the circumstances of the child, but I don't think there's mention of looking into the circumstances of a particular parent who may be under question or under examination. There is a provision that states the director may consult with the parent before removing a child, but once again, that language may, that's discretionary, so it's not mandatory. And I think that parents, especially in circumstances like this, where you have such a draconian measure, parents are afforded that right of consultation, their right to be heard, to be listened to, and even in situations defend themselves. Because as we know, we live in a society where there may be allegations or accusations which may not necessarily be true. I've seen it time and time again where there are persons who may be aggrieved by the other parent. So for example, the mother of a child, she may be aggrieved by the father of the child and she makes certain accusations which may not necessarily be true. Do we just then remove the child from the care of the father because an accusation like that was made? Or do we actually give the father the right to be heard by consulting with him first and making a thorough investigation before the director then goes in and takes away that child? So I don't know if Comrade would like to add anything to that, but that would be my response.
Before that, on the flip side of your argument, suppose there were an instance where there is evidence, because you spoke about the situations where there was no evidence, but there is evidence of whatever the accusation is. Is it still your view that that parent needs to be consulted?
I think where there is strong enough evidence, of course, you wouldn't want to create a situation where you're putting the child or keeping the child in that environment. But then that needs to be made clear in the legislation. I don't think that's
Because I
made
think
clear.
that is what the use of may contemplates. So as you are thinking, if you may wish to propose language that in your view can strengthen it, because we went through this when we interviewed the child care board and so on. We had
Yes.
some discussions,
Yes.
and that is specifically what it contemplates, that in those situations where there is
Right.
that clear evidence, you don't need to consult.
Yes,
That
so
period.
I do have language, actually. I think if we remove the word may and replace it with shall, but then put a proviso, which says basically, the director shall consult with parents, and then the proviso would be unless there is reasonable evidence or strengthly evidence or weighty evidence which suggests or points in a direction where there's actual neglect and abuse. So I think the starting point should be the enforcement of the right. And then, as we know, all rights are not absolute. So you would then put the proviso, which would then suggest, well, you do have a right to be heard, but only if it is that there's not evidence pointing towards neglect or abuse.
CPC.
Chair, just to indicate that when it speaks to the principles to be applied in the administration of the Act, Clause 4, F, where a child is removed from the home of his parent under this Act, whether temporarily or permanently, he shall be entitled to a safe, nurturing, stable, and secure environment, and the child may retain relationships with people significant to the child, including his parents, relatives, peers, family, friends, community, unless it is contrary to his best interest. That understanding of best interest would then be referred back to Clause 3.2, that speaks to in determining what is the best interest of the child. And the following matters will take into account: the safety of the child, the capacity of the parent to properly discharge his parental responsibility, the physical, mental, emotional, or psychological needs of the development of the child, the appropriate care or treatment required to meet the needs of the development of the child, where appropriate, the views of the child, a secure place for the child, the positive development of the child as a part of the family, a member of the family, love, affection, ties between the child and other persons in the life of the child, the capacity of persons other than the parent to exercise custody rights and duties in relation to that child, and the continuity of the care for the child and the possible effects of disruption of the care of the child. In addition, the bill also speaks to the power of the director, Clause 31 speaks to the power of the director to remove a child in very restricted circumstances. And those circumstances are very clearly articulated. So that where the director has reasonable grounds to believe that the health or safety of the child is in immediate or in imminent jeopardy, and there is not enough time to apply to the court for an order under Section 32, the director may, if necessary, and with the assistance of the police officer and without the need of further authority, enter and any place where the child is believed to be present or to reside or search for and locate and take the child into custody. And of course, there is the restriction there that is purposely put in to make sure that the director then goes to the court to get the order that is specifically meant for the particular circumstances in Clause 32. Your attention is also drawn to Clause 34, which speaks to the emergency protection order. The court shall make an emergency protection order where it is satisfied on the basis of an ex parte application by the director that the child is suffering or is likely to suffer physical, emotional, mental, or psychological harm and is in need of care and protection. And inquiries as to whether the child is suffering or is likely to suffer from physical, emotional, mental, or psychological harm, being frustrated by access to the child, being unreasonably refused, and the applicant has reason to believe that the access to the child is required as a matter of urgency. So that there are clear circumstances in such cases to deal with the emergency protection order and dealing with custody. And further, Clause 37, which speaks to the care order. The care order shall be made for the purpose of removing a child who is in need of care and protection as defined in Clause 5 and placing the child in the care of the director. That is the place where the care is placed in the director in the context of the court order. That those are clear, right? And the court may make a care order where it is satisfied that the child is in need of care and protection. You can go on then to Clause 42, which is a custody care order, where the director assesses that there is not a realistic possibility of restoring the child to the custody of the parent pursuant to the provisions of the Act. It is the best interest of the child that he no longer live with the parent, and at least the restrictive option is not available. The child shall make an application to the court for custody order. So it would not be accurate to say that there are no parameters, clear parameters that speak to when the child can be removed from his environment. Thank you.
So your response, CPC, is that the pieces taken together address the concern that was raised specific to the use of may and the proviso and so on.
If I may, thank you. There's a few matters that I have been following in terms of the discussion, in terms of the compliance issue. I believe that most of the concerns that we have is the removal or the avoidance of parental rights. The last bill that we had, the ones that centuries, years ago, that we had, the previous bill called the Prevention of Cruelty to Children, did speak of parental rights. This current bill actually violates parental rights because there are other treaties that we have signed onto that deals with parental rights but only addresses children's rights. We're discussing in terms of the American Convention of Human Rights, Convention of Children's Rights, also in terms of International Convention on Economic and Social and Cultural Rights. All of those treaties, Barbados did sign on to it, that covers parental rights. The other aspect that we want to look at is that what I'm seeing is that we keep going back into a regressive cycle. We are saying that, just want to go back in terms of a child need of care and protection, the requirements that you've given parents, and I'm talking about the average Barbadian parent. The outline here stipulates that this is what a child requires, a child in need of care and protection, and it outlines, which means that if any parent violate any of those terms, the state or the government or the agencies have the right to intervene. And this is where the problem comes in first and foremost. And we're not looking at this bill in isolation. So even when the director does all what is required, the procedures and the step, but the bill tells you that these are the requirements, and it clearly outstates it, and so that it shows you that if at any point these conditions are violated, the state has the right to come in. So it's not that it's just only in terms of bodily harm and physical harm and emotional harm and all this, but all of the requirements at any point the state can come in. The other aspect that I wanted to look at is in page 16, section 2, that deals with the best interests of the child. And we're going to come back to that conversation because there is this presumption that the state is the one who determines what is the best interest of the child. Historically, it has not. Biologically, it has not either. Because every single parent, and we're talking about rational parents, sensible parents, good, loving, God-fearing parents. The reality is that in this bill, it presumes that the state is who determines what is the best interest of the child. And to remove parental rights from this aspect, as I said before, we cannot speak about children's rights if we do not have parental rights to guide this legislation. Because at the end of the day, parents are the only one that would really protect children, even against the state. And we've seen situations like that. We've had cases where the state decides that it wants to mandate vaccination for children. Or we've had cases where the state decides that they will have different types of surveys without the consent of parent. So the reality is that we have to have a very clear definition of what parental rights are so that the state does not infringe or override on those parental rights when it is trying. Because when you creating laws and legislation, we have to ensure that it is just and it doesn't deprive anyone of their own fundamental rights. We do all of us in here would believe that we need to protect children, even against themselves, even against us. But at the same time, we cannot remove parents from the conversation. So in section 2 here, where it says in determining what is the best interest of the child, it is not the state. The state can't outline all of these provisions. It can't say that because the safety of a child, for that mother, she felt the safety for her being homeless was to bring them at the homeless shelter because she felt that was the best interest of her children. So we have to take in those considerations. As I said before, when we're dealing with legislation, this is abstract, but the reality is out there. When we leave this room, how do parents recognize and how they deal with this bill? And the reality is that how will it affect them? So we need to deal with the problems now, whatever anomalies that is there, whatever ambiguities that is there, let us try to address it before it goes to the public domain to avoid parents and children being placed in circumstances that technically they may not be able to deal with in the long run. Thank you.
If I might just add before there is a response. Also, we have lots of sections which deal with the protection of children from the parents. But what about the protection of children from the state? We have a situation not too long ago where there were allegations about the industrial school. So what happens in those type of situations where the child is removed from a potentially dangerous situation but then put in a even more dangerous situation. Where are the sections in the legislation which deal with that? Also, I heard mention of various orders, but being a legal practitioner myself, we know that sometimes orders is not something you get overnight. So is it that the application will be dealt with as an urgent application, which has like 72 hours or so to be produced, or will it go through the ordinary court system? Because if it goes through the ordinary court system, we may have a situation where the case is pending for months. What happens then? What happens where the child is removed wrongfully based on wrong accusations, and then there's an appeal made, but the appeal takes months, sometimes even years, to be heard and to be finalized? So what happens then? Or the flip side, there's abuse, and you have to get an order, and the situation takes months to be heard. So you have a child which is in that dangerous situation, but then because of the court system we have here in Barbados, I mean, there is no secret. We really have a backlog of cases. So what happens in those circumstances?
I'll just add to my colleague that the state, the way that the bill is written, the state actually exonerates itself. So if someone, when it speaks about cruelty to children, so if cruelty to children is done in the state's care, it's almost like 10,000 and 2 years. So the person is charged 10,000 and 2 years. But if a parent commits the same offense, it's 100,000 and 5 years. So these kind of anomalies, and it's also in the Justice Act as well, which we'll not touch in as well. So when we look at in terms of the penalties, the state almost wants to remove itself from responsibility, because we do recognize that neglect, the state defines neglect in terms of the parent neglecting children and not the state, because the state should be held responsible as well if it neglects the children, if they are in its care. But the penalty is different. If cruelty is done to children in the state's care, the penalty, there's an inequality in terms of how it is distributed. So it seems to penalize the parent more for the same harm that has been done to children. And we have to recognize that as well. And so in most of those cases, as I said before, we are here, the Democratic Labour Party is here to provide the assistance that is needed so that we can provide the aid. Even in abuse, we recognize that we would like to applaud that we have child labor. But child trafficking is also a very serious concern. We've had one case of child trafficking in Barbados, but we've had not much reporting being done on it. I think the United Nations or United States Human Rights Report for 2022 speaks about human trafficking and child trafficking. And these are kinds of concerns that we have to look at. We also want to look at criminal, I would say that it is called criminal neglect in some cases, or criminal enhanced, where you initiation, gang initiation is also now being seen as child abuse, where parents or persons within the community get children to be indoctrinated, I would use, or initiated into gang activity. And so all of that we have to take in consideration because we can understand the new climate of things that we live in. So there's quite a number of new evolving concerns, the language of child protection and what evolves, and we have to prepare ourselves because this legislation may not be for our generation alone, because most of us here have passed 50, except my colleague here. And so it means that this legislation may last centuries. And so we have to prepare ourselves, as we have seen that science is moving faster than law. And so we have to ensure that all of those provisions are made. Thank you.
Ms. Bell?
Chair, just on the point of orders, now, in terms of the orders, Clause 34 makes provision for an emergency protection order, which would be done ex parte by application by the director. And we would have gone through the various circumstances and the procedures in relation to the orders. In terms of the application of offenses, you would note the language actually does say any person, this is the unsupervised or unattended child, any person having care, custody, or control of a child, any person. In cruelty, there is a differentiation, a parent or any person, but the term any person is used. When you look at the way that the penalty provision is in, then you would speak to summary conviction on the fine of 100,000 or to imprisonment for a term of 10 years or to both, having regard to the Interpretation Act, which speaks to the fact that we express our statutory penalties in the maximum, that is from 1 to 100,000 to 1 to 10 or to both. But the point is that that person also captures the abuses that could be put in relation to the state. And additionally, even if there was asserted a defense of doing things in the best interest or in the course of their duties, it would have to be proven that their specific action was justified in the carrying out of their duties, which you could not say that these activities were. There are a number of different things that would have been said. And it is important to note the invocation of the jurisdiction as articulated in 5. And so therefore, it is not dealing with care and protection. It's not dealing with parenting in a general sense, but where there is an issue in relation to whether the child is in need of care and protection, that is when the jurisdiction is invoked. You cannot also divorce it from the investigation and intervention powers as articulated in Part 3, in which it was stated that the circumstances of the family, the economic circumstances, can be brought to bear when the director makes certain decisions. Going back into no, I'm not sure about the 2 years or both or the 5 years, because when you're looking at the legislation here, and I don't know if it is a version that you have, but the stated penalty at 60, for instance, is liable on summary conviction to a fine of 25,000 or to imprisonment for 5 years or both. And in cruelty to children, it's fine of 100,000 or to imprisonment for a term of 10 years or to both. Right? The only time that 2-year thing comes up is in terms of impersonation of a member of the board or the staff in relation to the authority. So I'm just pointing that out. Right, yes. Again, we stress the fact that we're speaking about a person. Right. In terms of the articulation of parental rights, this would have been spoken to in Clause 2 in relation to parental responsibility. Which means the rights, duties, powers, and responsibilities and obligations that by law a parent has in relation to a child. Law meaning the enactments that are set out, that are passed by the Parliament and subsidiary legislation, and law relating to the case law coming out of the courts. And does not include the right to consent or withhold consent to the making of an order on the Adoption Act. So that's a different category, but it does speak to the articulation of how parental responsibility is to be understood. So that therefore, I again have to stress the invocation of the jurisdiction. the fact that it is supposed to be directed at care and protection of children, for children in need of that care and protection, and not as a general thesis on how one raises one's child. That is not the substance or the focus of this bill. It is to deal with the care and the child in need of care and protection. There are prescribed principles that are to be applied in the administration of the act, and you would see them at 4, to which all of the people involved, including courts, would be bound to. So I just wanted to articulate those things, and I will end here, Chair.
Any member of the committee wishes to offer a comment or ask a question? If I hear none, is there anything further from Ms. Trotman or Ms. Dujon?
There's just one final point. I don't want to keep you back the whole morning, but I appreciate the stress on the word jurisdiction, but you said supposed to be. We know a lot of times things which are supposed to be are not necessarily done. So even though the jurisdiction is supposed to be for those children in need of care and protection, because the language, which is what is actually there, it says an act to make provision for the reform of the law on the care and protection of children. That's very general, it's very wide, and I think that this piece of legislation can be used and abused if the language is not rectified. So if it is that the jurisdiction is supposed to be limited to those circumstances where children really are in need of care and protection, the language of the bill needs to make that expressly clear. I don't think that we want to risk a situation where it's left open for interpretation, and it's something that can be fixed very easily just by inserting a couple of words. I think that mischief can be cured.
Anything further, Ms. Bell?
Chair, the submission is noted, and if it would provide for greater clarity, I have no problem in the insertion. However, it must be noted that you have to take the law or the entire statute in context. And so therefore, the context that the bill speaks to is actually quite clear. However, to my mind, if it makes it more understandable, the intervention can be made. Thank you.
As Bajans would say, pellucidly clear rather than pellucid. Okay, and given everything that we have heard this morning, we want to say thank you for the intervention. I think we have benefited from the discussion. I also think it's necessary for me to highlight the fact that once the bill is proclaimed, then I'm sure you're familiar with the fact that there are a number of regulations that will follow, and the regulations then make very express and explicit how things are to be done in ways that the law, you won't burden it, the law with it, my words, put it into the law and make it extensively long and more difficult to read for laymen like me. But the regulations make it clear how things will be rolled out. Also, what will be done is that there has to be an extensive process of public, not consultations, but what's the word I'm looking at? Not only public ventilation, sensitization is the word that I'm looking at, because you would recognize that for an attorney, you may be able to read into it and recognize certain aspects that you may or may not abuse. But for everyone involved, those who are the users of it, whether in institutions like the Child Care Board, whether they are parents, general society, the bill has to go through that period where we are sensitized on it, and I'm sure during that process as well, there will be further clarification of a number of things. It would be useful, and we thank you. We've come to the end of this particular session, I would encourage members of the committee to get up and stretch their legs for 2 minutes before we bring into the Senate chamber the final set of parties for the day. So again, thank you, ladies. Do
Thank
enjoy
you for
your day.
having us. Thank you, everyone, and keep up the good work.
Yes, thank you so much.
The committee is back in session as we welcome members, representatives from the bar with us again today. Glad to have you. We have received your written submission. I will not knock you for the timeliness of it, but we received it and we and we are grateful for your cooperation. What I would allow therefore for you to do, see now you have 2 bites at the cherry. If I were following strictly, then I should tell you that you have about 32 seconds left from last time. But your 15 minutes begins again, so we look forward to your summarized presentation this morning. Thank you.
And thank you again, Madam Chair, and to the Joint Select Committee. We are indeed very pleased that we have this opportunity. We do not take it lightly. Our submissions today will be in respect of the Child Protection Act. With respect to the Child Justice Act, the family law practitioners are in consultation with the criminal law practitioners, as you could appreciate the interconnectedness between the two. So therefore, we respectfully ask for a bit more time with respect to the Child Justice Bill. There are actually quite a number of complex issues that we wanted to sort through. So we will be presenting today on the Child Protection Act. Again, today we have the eminent attorneys, Ms. Margot Green, KC, and Ms. Pettigay Librace, leading family law practitioners. Thank you.
Thank you. Good afternoon, everyone. This presentation will be based primarily on the Child Protection Bill. I trust that all of you have the written submissions, which we would have sent on before. So I'm just going to go through briefly. Your chairman might be pleased to know that we can complete this within as many seconds as she wishes. We can certainly do it in the 15 minutes that is allocated to us. I'll start on page 2 with the definition of child. I've noticed in the bill that the definition says simply someone under the age of 18 years. Our concern about that is that you can get married at age 16 with your parents' consent, and if the parents' consent is unreasonably withheld, you can go to court and have that dispensed with. So it is quite possible for you to be under the age of 18 and be a married person. So in those circumstances, I think the definition would have to be amended to say something like those. Well, the draftsman would know what to say. Persons under the age of 18 who are unmarried or something like that. But we are not draftsmen. They would know exactly what to say. This is just to point out to them that the definition should include or should refer to those who are under 18 but who can engage in adult activities. I'm sure most of you would know as well that you can consent to sexual intercourse at age 16. And I think under the Factories Act, within certain periods of time, you can work. You can be gainfully employed. You just have to be outside of school hours and before darkness or something like that. So there are lots of adult activities that a child can do. Emotional abuse. We noticed that this spoke about psychological pain or injury. I'm not quite sure what is psychological pain. I don't know if that can be defined, or I don't know if that should be included at all, but that is for your consideration. But I thought I would draw it to your attention. I don't know what psychological pain is. We went through financial abuse, except that the way the financial abuse is defined seems to me to refer to acts by third parties in relation to the child, as opposed to an act that is perpetrated against the child directly, such as interfering with money to which the child may be entitled, or assets to which the child may be entitled, or coercing the child to do something with his or her assets, which might be held in trust for that child. I felt that the definition could be broadened. The word guardian, I would, as I've said here, I think that it should include a person who has care and control of a child, and not limit the definition to someone who assumes or has the legal responsibility and an authority to make decisions. It is quite possible for you to have that responsibility without having the child in your physical care, as happens when parties divorce. Custody is joint, which means that both parties have a right to have a say in what happens to the child. But usually the child lives with only one person. So that person has care and control of the child, and we felt that that person should be brought into the net as well, rather than simply someone who has legal responsibility, who can simply be a guardian or a grandparent or an aunt, or even just perhaps somebody appointed, a testamentary guardian, somebody appointed through a will. Feel free to ask me any questions as I go along. Yeah. Parent, we felt that the definition should reflect today's reality, such as where you have surrogacy, people who might give birth who have no biological connection to the child. So it was felt that since I believe this legislation is meant to last for several years, that you should extend the definition to include a child that is born in those circumstances. Physical abuse, I was not sure what kind of omission can be regarded as physical abuse. I would have thought that physical abuse meant actual perpetrating an act against the child, but maybe you have a different idea of what physical abuse is. So we did query the word omission being included there. Verbal abuse, it was said here that verbal abuse could, in the same basis, to include behavior communicated by silence. I am not so sure. I felt that verbal abuse should include words only. Maybe you'd have to have a different category for behavior which is abusive and which is conducted through silence. I don't think it should come within the purview of verbal abuse. It should perhaps be, I think it should be included. Silent treatment can be awful, and it is a form of abuse, but I don't think it should be included under verbal abuse. It should come on its own. I think I get what they were trying to get at. Now, Section 3, in relation to the views of the child to be sought, it might be useful to have an age limit imposed here, since the definition of child says anyone under the age of 18. I expect that there will be regulations to go with this bill when it becomes an act, so that can set out how you will get these views of this child. It is felt that adults, persons who are not trained in how to deal with children, might not necessarily know how to get their views. Children might say, because you are authority figures, they might say to you what they think you want to hear. So you might not necessarily be getting an accurate reflection of their views. Therefore, it was felt that you should either have some age limits, and if not in the actual bill, in the regulations, you should set out how you will arrive at finding out what the child feels about a particular situation. And we have felt that it is best to go through the experts, or psychologists or psychiatrists, depending on the circumstances. It's the same thing where you're seeking the child's views, as set out at Section 4, page 17. Section 4, this business of whether a child is temporarily or permanently deprived of his family environment, that he shall be entitled to special protection and assistance from the government of Barbados. I didn't think that this should be included. We felt that all children in Barbados are entitled to special protection and assistance from the government of Barbados, and this could be viewed as being discriminatory. So that should either be looked at again or phrased in a different way. I think I understand what you're trying to get at, which is that you want children who are placed in vulnerable situations to be taken care of by the government, but perhaps it should be expressed in a different way. Section 5, the inclusion of the word moral danger, I think is ambiguous. I'm not quite sure what moral danger is. Perhaps the priest who is here with me can explain in more detail, but I am not quite sure what moral danger is. I don't know if it would be like, what moral danger would be like watching pornographic movies or something like that? Is it of that nature? Well, perhaps you can put then, you can refine it in the regulations. Yes, and as my colleagues are pointing out, moral can also be subjective. What is moral for?
You will not get extra time for engaging Reverend Rogers, Senator Rogers.
Sorry. Yeah, what's moral for Jehovah's Witness is not moral, is not immoral for, might not be the same immorality for an Anglican, so, or Muslims, yeah. We are now having a multicultural, multi-faith society, so we need to look at that a little bit more detail. Pardon me, Section 5, where it was felt that based on what is the way this is phrased at present, the victim of domestic violence can also be, it seems as though that person is liable to be punished as well, by perhaps taking the child out of his or her care. Like, let's assume that the father has got beaten up and an application has been made for the child to be removed from the home. If that father is a loving father, then he is punished as well as the child is punished by being separated. So perhaps we need to look at that again and refine that section. Section 5, I wanted to find out whether or not this seems to give the child the ability to initiate action on his or her own without the assistance of a parent or guardian. I don't know if that is intentional. I think it is, it should be allowed. I quite like that I welcome that section in the Act, but I wasn't quite sure if this is what was required. Perhaps we need to make it clearer. Section 7, I've mentioned that already about an age limit and how you find out what the child's views are. Section 7, the child being entitled to legal representation, that this happens at present. I think it should be made clear in the regulations that if a child is going to be represented on its own, then provision should be made for the payment of the attorney, so it doesn't come from someone who will control the attorney who is taking the instructions. Section 8, which establishes the authority. I was wondering if the authority will also be regarded as the central authority for the Hague Convention. You might not think it, but Barbados has quite a few cases involving children who are abducted and taken away. And for most Barbadian litigants, it is exceedingly expensive to pursue the... That was last time? Okay. So that being the case, I'm moving fast. It would be appropriate for you to make it clear, because although Barbados has acceded to the Hague Convention, we haven't put in place the domestic regulations, and it really leads to trouble. So Barbados is also an attractive destination for persons who wish to take off with other people's, with children in ways that are not legal. You wouldn't think so, but that is true. The mandatory reporting. No, I think we started to deal with this on the last occasion. The doctors are having a concern with this because they feel that having to report in a mandatory fashion could lead to a breach of their doctor-patient confidentiality. And you've put in a caveat for the attorneys. You may consider doing the same thing for doctors. Doctors also felt that if you don't do this, you could send children on the ground to seek medical attention from unsavory practitioners or those who aren't licensed to practice at all in order to escape having to having their information being made widespread or being told to the authorities and getting the state involved. Catholic priests, I can't speak to Catholic priests and the sanctity of the confessional seal. Ms. Libres can do so. So perhaps you might wish to tell them, what is the confessional seal for Catholics?
Simply put,
Yes, Maria.
right. The confessional seal is the sacrament of reconciliation is a sacrament under the Roman Catholic rite, and the priest there is bound by vows of confidentiality. So in the same way that lawyers are protected, the confessional seal should also be respected. This does not mean that if a priest has knowledge of some impropriety that is captured under this section outside the confessional seal, that he's not mandated to report. But the exclusion here that we are proposing just captures the very strict confessional seal. So what other countries have done is that the way that it is approached is that what is said in the confessional seal, if something is flagged, try to get the person to repeat that outside the confessional seal, and then the priest will be mandated to report it. But you're going to have a challenge if the confessional seal is exposed under this section. So we're just asking, well, as a Catholic, I'm asking that that be considered.
Okay, Section 28 is pretty straightforward. Given the wide powers of the director, it's a welcome requirement that where a director removes a child under this section, he or she is required to apply to the court for an order within 24 hours. That doesn't happen now, and it has led to some unhappy consequences. So therefore, this is definitely a recommending section, addition to the bill. Now, the Section 32, I was confused with the notion of a custody care order. A custody order is different from a care order. I don't know if this is specifically defined, but custody means the bundle of rights relating to the care of a child, whereas the physical care is separate and distinct. So I felt that you should make a distinction between a custody order and a care order. They are two completely different things within the context of family law. So perhaps you should give that some thought. I don't think the two should be conflated. Section 34, the query here is what is psychological harm and how is it proved? And who is the applicant as referred to in Section 34 2B? And how is that person able to determine that the child has suffered psychological harm if he, she is not a psychologist, or if he or she has not taken the child to a psychologist? We also welcome the fact that an order of this type has a limited duration, even after it has been made 14 days. Well, that section 36 about the social inquiry report is pretty straightforward. That this is a codification of what happens at present. Usually, no orders are made in the family law court. Certainly where there's a custody dispute without a social inquiry report being done. It's usually done by the welfare department. I don't know if that is contemplated here, but I think they do very competent reports. Section 38, the court shall not make a final decision for the removal of a child from the care and protection of his parent or allocation of parental responsibility in respect of a child unless it has considered a care plan. This again is a laudable endeavor, but it should be noted that the only person responsible for preparing such a plan is the director. it would be useful to have an input from other persons, a psychologist, a psychiatrist, or even from the parents, since they would be the one with the physical care of the child. I think they should be involved in preparing the care plan. It shouldn't be left to the director alone, who would just be a state authority. Section 42, custody and care are two separate concepts, and that should be taken into consideration when you are using the phrase in the bill. Am I at the end? All right. Am I allowed to ask questions? Because I have some queries at the back of me. I want to know what was the jurisdiction of a bill. Does it extend to all children who are in Barbados, or only to Barbadian citizens, or only to children of Barbadian citizens? Does it apply, say, to children who are here temporarily, either because their parents may be on a work permit, or does it apply to children who are here as tourists? Who does it apply to? And how does this bill affect the common law remedy of making a child a ward of the court? Normally, where it is felt that a child is in danger, an application is usually made to the court to make the child a ward of the court so that the court makes decisions about that child's well-being. And it is interesting to note that the order is made from the time you file the application as opposed, you don't even have to wait until you get to court. It basically means that there's a presumption that the court will take care of the child, and you, whoever opposes the order, will have to prove that it should be removed rather than the other way around. The practical importance of the wardship has been curtailed by the existence of statutory custody jurisdictions such as the Family Law Act, the Minors Act, and the Maintenance Act, and such other types of legislation. But it still exists and is still in use. So I wondered if this, what was the effect of this legislation on that common law remedy? The other queries I had as well related to, I don't think I put it in there, but it occurred to me afterwards, the use of corporal punishment. I noticed that in this bill, you've only made reference to it in relation to child care centers, and those child care centers are defined, and they don't include schools or homes. So it seems as though we have not tackled that question of corporal punishment in this bill. And if we really are to protect children, I think we should deal with the issue of corporal punishment. So, unless you wish to consider that corporal punishment will fall within physical abuse. Those are my comments, ma'am.
Thank you for your comments, and over to Ms. Bell for her responses, initial responses.
Good afternoon, Chair. Good afternoon, all. Good afternoon, members of the Bar Association making your presentation. So just to speak to the jurisdiction, Section 9 of the Interpretation Act states that every enactment shall, unless the contrary intention appears, apply to the whole of Barbados. So the thing is that we don't do legislation to have extraterritorial application unless it is explicitly stated, and we don't usually do that unless there are very specific circumstances. So, for instance, with shipping or where you are extending the jurisdiction of Barbados to a particular place of diplomatic reasons or something like that, or with ships where that would be considered Barbados, but we don't tend to do extraterritorial, so it's confined within Barbados. In terms of the definition of child, as would have been observed in the previous presentations, you would have noted that the United Nations Convention on the Rights of the Child was an underpinning of the drafting of the legislation. By virtue then of the definition of child coming out of that convention, the definition of child was redefined to suit. Now, you would have noticed too that in the context of the Child Justice Bill, there would have been a sixth schedule that would have dealt with consequential amendments to various pieces of legislation, especially within the criminal context, where you were speaking to this particular peculiarity that we have in Barbados, where we talk about young person and child, right? And all of that would have been refined in that sixth schedule. In this context now, with relation to child protection, this has to do with this specific sphere. Now, the fact is that when you are dealing with reading of the legislation, everything has to be read in pari materia, meaning that everything has to be read together and constructed together. So it is not a situation where you would not take into account the laws, any other existing laws in relation to how the child protection legislation should be interpreted. So that if it is that you bring forward a particular accusation or a particular set of circumstances, and then the terms of the Marriage Act would be brought up, then the fact of the matter is then that would have to be taken into account in the interpretation of how the child protection law would be spoken to. In relation to the definition of psychological pain as not being defined, in terms of the canons of statutory interpretation, you will note that one of them is that where the Act may not provide for specific definitions, then the court is allowed to rely on the ordinary dictionary meaning. Other canons would be that the use of the word would be taken into account in its context, so that here you would speak to the looking at psychological pain, and you would refer to the ordinary dictionary meaning, as well as what would be contemplated by what is supposed to be protected under the bill. Now, that would be further articulated in Clause 5, which speaks to what a child in need of care and protection would be. And within that context, that is how psychological pain will be interpreted. In terms of how it would be proved, there would be a requirement then to depend upon expertise to make to put forward the support for whether psychological pain or injury has been caused. So those are the ways that you would seek to establish that psychological pain. In terms of financial abuse, where you're talking,
May I ask one question, please?
Oh, sorry.
Am I allowed to ask you anything?
Proceed.
Thank you, ma'am. If you're given psychological pain, it's ordinary dictionary definition. That's not what the expert is going to use. So if you're going to rely on the expert, then you wouldn't use it, the dictionary, ordinary. Remember, it's ordinary garden variety lawyers who will be using this legislation. So if you're going to use I find that a bit confusing. If you're going to use the ordinary dictionary meaning, surely that is not going to be, and you're still going to be relying on the expert to prove it, then that expert is not going to be using the ordinary dictionary meaning. So.
Chair, through you, just to go through what the ordinary dictionary meaning would be. Psychological means the affecting or arising in the mind, related to mental or emotional state of a person, pain, mental suffering or distress, injury, harm, or damage. So the question would be then, can having ventilated with the the professional involved, can these results be recognized from a professional level? That's how you would be able to establish it. Chair, in relation to financial abuse, where you're talking about including withholding the financial support necessary to maintain a child. Now, you could possibly delete it, but the thing is that, is it something that ought to be recognized from a policy level? These, many of these definitions have been informed by reference to a particular model, which then would have, and this is OECS models, right? That would have imported with them certain concerns about what should be protected and what should not be. And so as a matter of policy, the question is whether you want to take this out or not. This is something else. And then in relation to your submission about the fact that the definition should refer, well, that the definition of financial abuse, that it usually includes identity theft, are you recommending then that it should be expanded to include identity theft?
Yes, that would be the recommendation. You see, with respect to the section that says, when it says withholding financial support necessary to maintain a child, that would usually be the purview of the parent, rather than, because it would be the parent who is entitled to receive the support for the, which would be maintenance, I assume, for the child. So I don't see how it would impact directly as financial abuse, if you see what I mean.
But then
And
it
also through
Yeah.
you, Chair, before you
Oh, sorry.
answer, also, what about a situation where a significant asset was left for a child? It's not just financial support being withheld. A significant asset or monies were left for a child, and that person either manipulates the child or deprives the child of that asset. And in a real way, we live in an internet world. Children are making money from the internet and could make money from also in their celebrity status, in their, with respect to a particular talent. So that child may be deprived of earnings while it is a minor. Someone could be perpetrating financial abuse. So we're asking you to expand it, not to take out the financial support, because financial support is just a narrow aspect of financial abuse, which could be to disenfranchise a child from an entitlement that they may have when they become an adult.
Chair, just to acknowledge that I take the point in relation to that aspect. So it's just an expansion then, just to cover, an expansion then to include identity theft, and then also those specific earnings that could be generated
Earnings are inheritance.
Earnings are
Yes.
inheritance.
Are
Okay.
entitlements, yes.
All right, okay. Chair, through you to continue. The definition of guardian as having legal responsibility and authority for the making of decisions with respect to a child. So in the context of the bill, we're looking at the person who would be responsible for that child. When you look back at the when you look at parental responsibility, the definition in clause 2, it speaks to all of the duties, obligations, liabilities, etc., that are imposed on the parent or are the responsibility of the parent in accordance with the law. And so therefore, that is what would have informed the legal responsibility for making decisions with respect to a child as it relates to the definition of guardian. In relation to a parent, the bill is not speaking to the definition of parent in the widest sense, but specifically the parent who would have the legal responsibility for the child in the circumstances, because at the end of the day, the bill, as would be spoken to in clause 5, the intervention is based on whether the child is in need of care and protection. In relation to the definition of physical abuse, where it is queried if the word omission should be included here. Now, I have the comment that it can be deleted, but the thought process was basically that if it were that by your not doing something, it resulted in abuse, then it should be taken into account. However, perhaps it is that you need to revisit then what omission would cause and then revisit to suit. If you're thinking that it should be more precise in orientation. This is similar, would not be similar with verbal abuse, but I take the point that the reference to silence can be deleted, and so it is a form of abuse, but would need proper separate articulation. So I can take the point in relation to those definitions.
In relation to acts of omission and silence. We think that they should be dealt with separately. They are important and they should be taken into account because they can affect children adversely. So, but they should be separate.
Yes, so so that can be taken into account, that omission should be dealt with separately, and that the reference to silence, that the use of silence, we would have to find the appropriate terminology in order to insert, but yes, it could be dealt with separately as well. In relation to the views being sought and the insertion of the age. Now, clause 3.2 and clause 7, which speaks to the parameters for the participation of a child in the context of decisions having a significant impact on him, you would note clause 7.2, there is given the opportunity for the child to freely express his views according to his abilities, age, maturity, and developmental capacity. So it is not that it is just to be blanket, but that you would take into account the age of the person and their ability to express. The point is to give a platform for the person to, or for the child to participate in those decisions. It is noted that further articulation can be taken in the regulations, but I would draw to your attention to the fact that it is said that it is a situation where you're trying to provide that platform for the participation, and that the child's age would be taken into account in terms of the capacity to even be able to submit for those purposes. In terms of 51F, the word moral, now this has been identified as a
Madam
problem
Chair,
area. Oh, sorry.
May I make a comment, please? May I just comment on what she
Go
just
ahead.
said? Yeah, thank you. We still have a problem with leaving a method of gathering a child's wishes so open-ended. So you
I didn't hear that, the method of,
getting the child's views so open-ended, so you don't have any restrictions. So you can get the wishes of a 2-year-old, presumably, or a 6-year-old, or a 10-year-old. I mean, I know this is not the Family Law Act, but in the Family Law Act, a child whose wishes are taken into consideration will be from the age of 16. Granted, I think it could be an earlier age, but I still think that there should be some indication as to at what age it is appropriate to take this into consideration.
thank you, Ms. Bell.
Yeah. Yeah, Chair, through you, just to point out the persons who would be involved in taking this information, even in clause 7.2, it speaks to the director shall provide the child with the following. The director then, with their expertise, most of them having a background in sociology, psychology, and the like, would be trained to take that information into account in a way that respects the fact that you're dealing with a child. In fact, that's how they are supposed to be trained. Again, you cannot, this is an area that then has to be dealt with in the intervening period, because this bill is supposed to be subject to commencement, subject to proclamation. Certain administrative interventions would have to be made in order to make it or fully flesh out. But the presumption is that the director, it would have the capacity, and their staff would have the capacity to be able to collect information efficiently from a child.
Madam Chair, if I may, you're going to have a problem. If the director is tasked with finding out the views of the child, he or she is going to be conflicted, because he or she is mandated by the Act to, if he or she deems it necessary to seek a court order. What should happen is that really an independent person should interview this child. Perhaps you should have a cadre of psychologists or on call, that should a case come to light, that child is referred to one of these cadre of professionals on call. But you're going to have a challenge if the person who is to, under the Act, go to court for an order, be the one to be interpreting what this child is saying. You're going to have a challenge, because it is not going to be an independent assessment.
Chair, but the Part 3 gives the capacity for the director to do investigations, to do interventions, and other types of activities. And as such, they have to be equipped with the capacity to take the necessary information that they require. So that would also include dealing with the participation of the child under Clause 7. But you would also note that if there is an issue in relation to the position of the director, that can be challenged also through Clause 7.5, which allows for an appeal of those decisions.
And through you, Madam Chair, we're just saying that as attorneys at law, we quickly see the areas for challenge. So it's just a matter of indicating what the priority is in respect of the Act. But I would say that you will find it repeatedly challenged if there's not that level of independence between the person who is seeking the views of the child and the child care board or the authority. Thank you.
And just for clarification, the court has very strict guidelines as to who is able to present to the court wishes of the child. I mean, it's not at large. It is recognized that the ordinary person, however academically qualified, is not specialized to tease out what a child is actually saying. You have a myriad of circumstances or situations where children come to you and telling you one thing, but unless you are properly trained, what the child may be mouthing is exactly the opposite to what they're really feeling. And caution must be taken. So just saying that the child care director has a sociology degree or a psychological degree is a degree in psychology is not enough. It is an area that is specialized. So there has to be some caution here. Getting the needs of, getting the views of a child, particularly if the child is a young child, I can't express enough that caution needs to be taken because you're going to run into problems. And if you want a matter tied up in the courts for years and years without resolution, this is where this is heading.
Chair, this particular provision exists from an OECS model that is successfully operating in several other jurisdictions. St. Lucia, Grenada, Dominica, etc. It also operates successfully in Trinidad, which has light provisions. The director is identified in those pieces of legislation as having the capacity to deal with soliciting that information from the child, especially in the context of the fact that you would be doing a lot of the investigations, interventions under Part 3. So I'm just pointing that out for the purposes of the discussion.
Through you, Madam Chair, thank you. We just expressed our note of caution. Thank you.
Thank you. Any further comments, Ms. Bell, on the rest of it?
I'm sorry, Chair. I forgot to plot about Chair, in relation to 51G and the Bar Association, you would take note that I'm going through your matrix, so I'm trying to be as thorough as possible for purposes of discussion. Sorry, Chair. Best interest of the child, as defined in Clause 3.2, is the governing principle here. So where you were talking about the fact that there's a potential for the victim of the child abuse, the victim of the domestic abuse to be punished. But the fact of the matter is, it is the best interest of the child that has to be taken into account. And if it is in the environment that exposes them to danger, then this must be put at the forefront rather than the interest of the parent. So in context, that is what is communicated here. Chair, in relation to the need of this seems to Clause 5.2, a child in need of care or protection may seek the assistance of the director. So I think that it was asked whether or not this was meant to be there, and yes, it was an express intention, an express policy view to give the child a capacity to seek assistance from the director. Now, this has to be read carefully in conjunction under Part 3 with sections 23 and 22 and 23. So if you go to 22, clause 22, speaks to where the director may intervene, but also in drawing back to clause 5.2, you talk about the request for intervention. Here is where the director then would go into the veracity of the particular report. And there are specific parameters where the director would consider the appropriateness of providing or arranging such assistance as is necessary to enable the child and the parent to resolve a conflict without recourse to legal proceedings, to ensure that the child is adequately cared for, supervised, or protected, or enable the child and his parents to have adequate, appropriate services. It is not just something blanket, but that there is a weight that is given in relation to when you can intervene, and the empowering the director to ventilate, investigate as much as possible any request for intervention and any request for assistance. In determining, in clause 22, the appropriate response, the director shall have regard to the following: the immediate safety and welfare of the child and any other child in residential setting of the child, the age and maturity of the child, and the disability of the child, and the existing circumstances of the family. In relation to clause 7.1,
Ms. Bell, can you just pause for a minute? We have exceeded the time allocated for this session, so it may only be extended if there is a motion for an extension.
Chair, I'd like to move that there be an extension.
And I'm recognizing Ms. Cynthia Ford as seconding. Thank you. Proceed.
Chair, thank you.
Did you say an extension for 10 minutes? Did I hear that?
I didn't know, for 10 minutes.
Okay, thank you. And that's seconded?
Chair, well, I will try to, I just want to give you the benefit of the discussion. All right, so I will go to the clause 7.4, which speaks to the legal representation. So I take the point that the legislation should speak to how this representation should be paid. In the Child Justice Bill, we would have done consequential amendments where we intervened in the Community Legal Services Act to take into account proceedings in the Child Justice Bill. And in the same way, in the second schedule to this act, there are provisions for consequential amendments. So that kind of intervention can be made for there. As it relates to the concern about The Hague, now I would have spoken to this in the last presentation, but just to make absolutely clear for the purposes of persons who are streaming, there is transitional provision in clause 67, savings and transitional. So with effect from the commencement of this act, then the assets, liabilities, rights, privileges, obligations, and the like will transfer from the Child Care Board to the Child Authority, Child Protection Authority. As you would have recognized, the Child Care Board Act will be repealed, and so this transition then has to be done in order to preserve all the obligations that has to be met. And so included in those obligations, therefore, would be the same as regards to the Hague Convention. As it relates to the mandatory reporting, okay, from the perspective that there was opportunity given for consultation arranged by the ministry with stakeholders. Now, I am aware of that meeting, but I do not know exactly who was there apart from just the parties in groups, collective groups, and so that I can't speak to that. The ministry would have had to be here to give the full explaining of how that consultation was done, but there was a consultation. The section does have in operation the statutory exception in relation to attorney-client privilege, and that was mirrored in the OECS model, and so it was included here. Those models then don't include the doctor, patient, and the other matters dealing with the priest. And I suspect, as a matter of policy, it's excluded because let me speak to doctors. They would be in a position to see when there would be harm involved. In relation to the confessional, this is something that would have to be looked at from a policy level in terms of the inclusion. However, one of the questions that I would have is the flipping, whether or not that privilege should be extended to attorneys where you're given the seriousness of the matters to be reported. In a sense, that answers itself, because usually in legislation you would include that attorney-client privilege because it's imported as a part of general rights. But what I'm raising is that it's included, but then those other things need to be discussed at a policy level and properly ventilated and discussed. Oh, okay. Sorry. Okay, let me go to just some important ones. In terms of the custody care order, now I will say that we did go into clause 2 to define the orders, and the custody care order was not there. However, it is discussed in clause 42 as it relates to how it is supposed to be interpreted, as not to be confused with a custody order, which deals with the custody against the backdrop of the family law setting. So if I speak to clause 42, go to clause 42. Right. Which is where the director assesses that there is not a realistic possibility of restoring a child to the custody of the parent pursuant to the provisions of the Act, and it is in the best interest of the child that he no longer live with his parent, and a least restrictive option is not available, the director shall make an application to the court for custody care order. And that would then be put in place where, as you can see in clause 42.5, the custody care order places a child in the custody of the authority, so that the bill gives the parameters for how this order should operate. But as a concession to you, I can say that you would have insert in clause 2 the definition of custody care order as described in clause 42, which is how the other orders are defined.
Madam Chair, Just want to comment. I still think that I still don't see how you get a custody care order. Custody is one thing, care is another. I mean, as a legal definition, custody is one thing, care and control is something else. You can have physical care and control without having custody.
And
So I don't understand why you're calling it the same thing. Why you're calling it all one thing.
Through you, Madam Chair, we would caution because the Family Law Act, which is well established and over 40 years old with all of the provisions in the Family Law Act, they make it quite clear what is a custody order as opposed to a care and control order. So to create another type of order under another act in relation to a minor or child would only create confusion in the law. Respectfully. Thank you.
But Chair, if it is that you create those parameters by virtue of defining them within the context of the act, that confusion would not be there. And it is that we put definitions in various pieces of legislation, and the legislation itself provides the parameters for how it would be interpreted, and this is no different. You would have seen that you would have said a custody order as opposed to a care order, as opposed to another set of orders. And this would be understood within the context of the act as having to do with the director making a certain assessment and the court then being able to put the child in the custody of the authority for the purposes of understanding that you're dealing with the care and protection of the child.
Duly noted, it is our job to raise the issues and to say that if you wish to have this also caught up in court, please feel free. Thank you, respectfully.
Chair, in relation to the social inquiry report, again, there is provision within this act. It provides the parameters in clause 36 for how that report will be done. Now, you are now introducing the child protection legislation, and you're giving the parameters for conducting a report so that it would inform the court in relation to making certain decisions, primarily the giving of orders pursuant to Part 4, dealing with care and protection of the child. So I'm just saying that there are created parameters that are clearly set out in the act, the bill, sorry. I think at this time I will close. Just to talk about 38.1, where there's a part that talks about the inclusion of or reference to a psychologist or a psychiatrist. Now, we could include the comments of the psychologist or psychiatrist within the bill once the ministry is on board in terms of as a policy decision. So that can be done. Thank you.
Thank you, Ms. Bell. Any questions or comments from members of the committee? I hear none,
Let me just ask some simple question.
except Mr.
Oh.
Prescott.
In the interest of getting things as right as possible, outside the remit of the committee, people who specialize, professional people, especially in the law, related to the rights of children, would the committee recommend that a more extensive debate, not restrained by the time of this committee, could we recommend that, because based on what I am hearing, the refinements of logic is constrained by the limitations which we have around the table. And you're having practitioners doing an interpretation of the provisions within the law. And you're having a technical person also attempting to also explain what her perception is in relation to how we can interpret matters related to care and I think it's the custody. I wonder if within the interests of the highest principles that a society ought to accept, if those parties could be in contact with each other outside the formality of these discussions to see if they can pin this discussion down to the most practical kind of application of the legislation itself. I'm just wondering if we can suggest that, if that is something that can be accepted.
Thank you. And we recognize your concern as one to provide clarification, perhaps an elucidation more so for the public purpose. But even before coming to this point, there would have been provision for that, and the attorneys at CPC, along with other specialists that are attorneys and child advocates and so on, would also have had input into the bill along with the different, like the probation department, child care board, the different agencies and so on. So I don't think that it comes before this committee for us to suddenly become experts at law, but certainly from our respective perspectives to hear the different arguments and to have our own further reflection and balance these. But just for the record, so that the public can be satisfied as well as us here in the room, that these matters would have been weighed in on extensively over a period of time. And there's nothing even at this point in time limiting, not within the scope of this committee's work, but certainly for the bar or any other agency to reach out to those specific areas. What I would, to get further exchanges going, what I think would be useful, and I'm sorry that the ministry, the parent ministry is not here, because they would have the full list of institutions and persons that were engaged. I must admit that I'm limited in that regard, but only operating based on the recall that of some of the institutions that were involved. Child advocates who are also attorneys as well, who would have been examining the language and the implications and so on as well. All right. So I see that the representatives from the Bar Association are not asking for the mic again. So I take that to mean that they are satisfied not being in agreement, but satisfied that the exchanges have achieved as much as they can achieve. And so I
don't think the word satisfied would be quite accurate, Madam Chair. However, we have done our job and we are grateful to you for the opportunity. Thank you.
Thank you. I recognize Ms. Bell.
Yes, Chair. Just in relation to participation of stakeholders, certainly the model was informed by an expert in the field, consultant Jacqueline Seeley-Burke. Also, there were a number of stakeholder meetings with the probation department, GIS, criminal justice and research, the magistrates, the police service, the registrar, registration department, the child care board, the National Council of Substance Abuse, other ministries concerning the issue, as well as attorneys so I have that in the note, as also participation from international agencies. Thank you.
All right, thank you. And I think that that fairly brings us to the end of this particular session. And I can therefore entertain a motion for us to suspend for lunch.
Madam Chair, I'd like to move that we suspend for lunch at this time.
For 1 hour?
1 hour, yeah.
To resume at 3?
Yes, please.
I second that. I second that.
Thank you. We will resume at 3 p.m.
Obliged. Thank you so much.
Thank you, ma'am.
Thank you, ma'am.